Mr. Rubin.
Thank you, Your Honor. Your Honor, for 150 years, judges in cases in which defendants were convicted of murder were authorized to impose a life sentence. That was the only sentence available. In 2009, the legislature expanded the judge's discretion and now allows a judge to impose both a life sentence with the possibility of parole and a life sentence without the possibility of parole, and gives absolutely, as Mr. Goff pointed out, no guidance to the court as to what factors to take into account when differentiating between people convicted of murder. But I know this court, Your Honor, has been on the bench long enough and has tried a number of cases, including murder cases, in which you've had to make those decisions. And you've had to differentiate between defendants and be consistent in your rulings, in your sentencing, probably the hardest thing any court has to do, which is to sentence a person to time in prison. In this case, in which the state is seeking the harshest possible sentence allowable under the law, we're asking the court to reserve the harshest possible sentence under the law for those who deserve it, for the worst of the worst. When the facts of the crime show a darkness of soul, a person so depraved and heinous as to shock the conscience by their actions, or where the offender is such a danger as evidenced by his past conduct or by his actions post-offense, such that rehabilitation is remote or impossible, those are the offenders who deserve the harshest possible punishment under the law. Those are the offenders who people would argue deserve to spend the rest of their lives in prison. Neither of those scenarios encompasses Travis McMichael or the conduct for which he was convicted. And like Ms. Donikoski, I want to spend just a couple minutes reviewing the conduct for which he was convicted, because I agree with something she said, maybe for the first time in this trial. When Travis McMichael woke up on that Sunday morning with his son Everett in his house, his goal was not to go out and kill somebody. His goal was to play with his kid. When he sat down for lunch with Everett, possibly with Greg and his mom, Lee, and sister Lindsay, his goal was not to commit a crime that day or kill somebody that day. His goal was to have a family afternoon. And when he was putting his son down at 1 o'clock or so in the afternoon, he was doing what every single person wants to and should be doing, which is taking care of their toddler son. When he got in the truck at his father's behest to find out who that person was sprinting down the road, his goal still was not to commit a crime. His goal still was not to hurt that person, but to merely investigate, to find out what was that guy doing back at the house where Matt Albenzi was motioning. And then 4 minutes later, Mr. Arbery's dead, Mr. McMichael's covered in blood, and we have what we have here and what the jury heard. And he was convicted. The jury found that his actions constituted malice murder, felony murder, and the underlying felonies. But this is not a case in which he just targeted someone recklessly, targeted someone without knowledge, misidentified someone. He knew Ahmaud Arbery. He had encountered him previously. And he had known about the fears that the neighbors felt at Mr. Arbery's continued presence. I'm not going to retry the case. The jury found that those facts did not add up to probable cause and did not justify Mr. McMichael's actions. But he didn't just go out and shoot Mr. Arbery. He only fired the shots, the fatal shots, when Mr. Arbery came at him and grabbed the gun, as Dr. Donahue demonstrated. These were not, and as reckless as those acts may have been, as Ms. Donikoski pointed out, as thoughtless as they may have been, they are not evidence of a soul so blackened as to deserve to spend the rest of his life in prison. This was not a planned murder. This was not a murder involving torture. It was a fight over a gun that resulted in Mr. Arbery's death. And for that, the jury found Mr. McMichael guilty. The state contends that 99 good acts don't overcome one bad act. And of course, legally that's true. Mr. McMichael is now a convicted felon. But 99 good acts do weigh in this court's consideration, do factor into what choice this court is going to make when sentencing Mr. McMichael to either spend the rest of his life behind bars or give him the possibility of redemption. And those acts, those 99 good acts, the court heard about those in the bond hearing. The court heard that during his time as a lifeguard at a camp for kids who have family members with terminal illnesses, that Travis McMichael actually saved the life of a boy who was drowning in the pool. The court heard that Mr. McMichael, while serving in the Coast Guard, literally saved the lives of family members who were on a boat that was taking on water. The court heard that Mr. McMichael saved the crew of a Coast Guard vessel while serving in the Coast Guard. The court heard of the letters of commendation given to Mr. McMichael by his superiors for various acts that the superiors said show superior dedication, selfless devotion to duty and consideration of others, and adherence to our core values, honor, respect, and devotion to duty. They don't excuse anything that happened on February 23rd, but when the court is weighing in the scales of justice what people deserve to spend their lives and then die in prison versus those people who deserve to be punished but then hold out hope for redemption, those are the acts the court should consider. Mr. McMichael was a devoted father to Everett. He had Everett 50% of the time, shared custody with Everett's mom, and in fact, early on was shown to be the more reliable parent, although I know that changed over time with his mom stepping up. He was a friend to many people who are now too scared to come to court and speak on his behalf. As the court knows from the testimony it heard in trial and at the bond hearing, he was always a hard worker, always had a job, never laid around letting other people support him, always paid taxes, always supported his community in a variety of ways. The discovery that we received is replete with FBI and GBI interviews of people in his community, people who told law enforcement officials of the times Mr. McMichael helped them when they were having problems, when their boat became unmoored, or when their docks were pulled off from storms, and Mr. McMichael was out there finding those things and bringing them back to the owners or helping other people in the community, just as he thought he was doing on February 23rd. Actions that, in hindsight, turned out to be thoughtless, as Ms. Dunikowski said, were reckless, but were not evidence of an abandoned and malignant heart. Nothing in Travis McMichael's life suggests that he's a danger to society now or will be a danger to society 30 years from now, after he has time to think, to work, to grow. When he's in his 60s, older than me right now, do we still want a person like Travis McMichael behind bars? There's nothing in his post-offense conduct that shows that he's either mentally unstable or a sociopath. He cooperated fully with police. He told the police everything he knew to tell them because he thought he was doing the right thing, even if that thing turned out not to be right. He and Greg McMichael thought they were helping their community. They thought they were helping the police catch someone who inexplicably had been in a house, and we still don't know what he was doing in the house, on 4 or 5 different occasions. He never fled. He never tried to obstruct the investigation. When he talked to his neighbors about what happened, he always expressed remorse and disbelief. If life without parole is reserved for the worst of offenders, those who are so scary, so unpredictable, and so likely to pose a threat in the future, then it is not appropriate for someone like Travis McMichael. The only purpose of a life without parole sentence, Your Honor, is vengeance. It's retribution. And the urge to seek vengeance is strong and understandable in the family. Lord knows if I was in their position, I would be seeking the same thing. But vengeance is not the foundation of our sentencing in our criminal justice system. Redemption is. Redemption is the belief that a person can learn, can grow, and still contribute after punishment. It is pointless to continue to punish a person who has undergone changes in character that distance him from the person who committed the crime decades previously. Travis McMichael, 35 years old now, should have the opportunity to show that he's grown, to show that he's changed, and the parole board, years from now, is in the best position to determine whether he should remain behind bars or can serve a useful purpose to society. Who knows where we will be as a society in 30 years? Why make a decision today that impacts so many people long after we're gone, long after you and I are retired, hopefully, but that binds the hands of those who will have to live with this decision 3 decades hence? Why make a decision today that snuffs out all possibility of growth, of redemption in Travis McMichael? Compassion for Travis McMichael and the humility to admit that we don't know what's going to happen in the future doesn't diminish the compassion that we feel for Ahmaud Arbery's family. Their loss is real and understandable, and their desire for the maximum punishment is real and understandable. But again, that's why we have judges imposing sentence and not the families of the victim. Because there are a lot of factors this court takes into consideration: deterrence, rehabilitation, retribution. Those are all valid factors. But the only thing an LWOP sentence serves is retribution. Wouldn't it be healing for Mr. Arbery's family for Travis McMichael to atone, to be able to express the remorse that's in his heart without the specter of a federal trial hanging over his head? And we've heard several times today that he's shown no remorse, but this court knows that no lawyer would allow Mr. McMichael to say anything about his feelings towards the family while there were 2 pending murder trials against him. When the witnesses were interviewed by law enforcement about Mr. McMichael's conversations with them, to a person they said that he showed remorse, that he never wanted to kill somebody. He was merely trying to detain Mr. Arbery for the police. It is disingenuous and unfair to expect Mr. McMichael to express remorse with yet another trial beginning in 3 weeks, where everything he says can be used by the federal government against him. Wouldn't it be powerful, though, for Travis McMichael to look deep into himself and explore with the public, with his son Everett, why he did what he did, and in fact become a force for good while in prison and out, instead of one more old man behind bars costing taxpayers $50,000 a year or more in 30 years. Wouldn't it be healing to society for someone like Travis McMichael to be free to help heal the wounds that are certainly present in this country due to decades and decades and decades of discrimination, of racism? Wounds that we're just now beginning to try to heal. Judge, you can send a message that 4 minutes of conduct does not erase a life well lived, and that after punishment there is opportunity for redemption, an opportunity that Travis can either take advantage of and prove himself worthy or not, and that the parole board can then determine whether he should be released from prison. We are not asking you to do anything, Your Honor, but to agree that we don't know today what the future holds. We're asking you to sentence him to life with the possibility of parole if it's earned. Judge, as far as sentencing, I would disagree with the state. I believe count 7 and count 9 do merge. I believe the language of chasing Mr. Arbery through the Satilla Shores neighborhood that is stated in count 1 and also stated in counts 7 and 9